Hello and welcome to Absolute Trust Talk. This is our live stream podcast at Absolute Trust Counsel. I'm Kirsten Howe. With me is Madison Gunn, our associate attorney. We started doing this podcast because we wanted to provide information and education to our audience, which is largely our clients and people like our clients, people who have done estate planning or need to do estate planning. And this episode is no different. It's going to provide information and education, but it's maybe a little more fun than some of our other episodes. So you're going to get a little bit of sugar with your medicine today. What we're going to be talking about is estate planning mistakes that have been made by celebrities. And I'm talking about dead celebrities because you don't know it's a mistake until, somebody dies. You've probably seen photographs by paparazzi in People magazine where, the celebrities are out walking their dogs or pushing a shopping cart in Whole Foods parking lot or going to Starbucks. So we like to kind of see that celebrities are just like we are in some ways. And that is very, very much the case when it comes to estate planning. They make the same kind of mistakes we make. Yeah. And so we're just going to talk about some of those mistakes in the hope that it'll help our audience avoid making those same mistakes. And for those of you who listen regularly, you're going to hear some of these mistakes we talk about day in, day out, all the time. And famous people make them too. So, okay. Now, this episode really was Madison's idea, and I think it's a really brilliant idea. So I'm going to let her kind of lead us off. Let's just
all right.
Let's go down our list.
I just have to say that I guess that's why jeans and a t-shirt is my favorite outfit on a celebrity. Even though they're probably $200 jeans and $100 t-shirt, it's right. Still because it's normal, right? It's normal.
You like to see them in normal stuff. Yeah. It doesn't always have to be couture.
Yeah. So the first celebrity is probably, I wouldn't say the biggest celebrity on this list, but I would say the biggest hubbub surrounding his estate, and that was Prince Rogers Nelson, the singer or artist formerly known as whatever he is symbol. I don't even know how you would say that. He died without a will. He had a $300 million estate, his mansion in Minneapolis, his recording studio, all kinds of rights to music, whether it was his or other artists that he had acquired or produced. He owned all of that. He had no children, ex-wives, but no children. And he had absolutely no estate plan whatsoever.
Yeah. So that's a classic mistake. No estate plan, meaning everything's going to go by intestacy, and his intestate heirs were
his 6 half siblings.
6 half siblings.
Yeah.
That might not have been who he would have chosen if he had actually sat down and written an estate plan. And I just got to say, that kind of estate, it's not just real estate and bank accounts. That particular kind of estate with all those intellectual property rights and contractual rights, that's really complicated.
Yeah.
And now you're going to divide that in 6 pieces.
And it took 6 years to settle, which means you have 6 years of royalties and everything coming into the estate, which, they're going to argue over, do you divide it all equally, or do you, is there 6 interests to Purple Rain, or is somebody get that and somebody get something else,
Right. You get Little Red Corvette, I'll take.
Yeah. Exactly. So they settled it after 6 years. At that time, it was $156 million left to divide. I'm sure the government took their fair share of that. That's another problem. Well, yeah. Estate taxes too.
He did no tax planning. Yeah.
Yeah. No tax planning. And the siblings, in some sort of smart move, they did come forward, and 3 of them created one entity, like an LLC, and the other 3 created another one. So, that's smart on their end.
They've got some management going for what they ended up owning.
Yeah.
Because there's no way just some random person could manage any of that.
No.
You got to have expertise.
There has to be some sort of controls in place for like if Coca-Cola wants to use your song in a commercial, who gets to decide that and who gets to negotiate that and
Right.
all those details that we don't even hardly know. So
Right. Okay. So that we really started out with a bang. That was a big
yeah.
debacle, let's just say.
Yeah, I tried to pick a variety of celebrity of state. So I think I did. I think I did good on that one. So the next one is Whitney Houston. She did just have a will. She's from New Jersey, so that might be something that's easier than in California. The problem was her will was written a month before her daughter was born. I'm sure it acknowledged that she was having a child because it did say that 10% was going outright to Bobby Christina. But she wasn't worth as much then as she was when she died. So 10% ended up being $2 million when she died, given outright to an 18-year-old, which attracted, as we know, not great characters. So that wasn't, she got the rest at 21. She just didn't make it that long, unfortunately.
Yeah. And that is something that is really so critical for parents to plan out, especially, yes, she didn't know it was going to be that huge amount of money. That is transformative money.
Yeah.
And that transformation isn't always good. When an 18-year-old has $2 million, they make a lot of friends, and not
Friends,
necessarily the kind of friends you want your kid to have. So yeah. And just in case anybody doesn't remember the story, Bobby Christina is no longer with us.
Yeah. And you know, that's the cautionary tale of revisiting your estate plan. Even if you don't think you need to make a change, you can talk to your attorney and just let the attorney ask the questions to flesh out maybe things that you hadn't thought of.
Right.
Most people don't want their kids to get that much money. And especially in her situation, I don't think it would have made it any better had she survived at 21 and received the other $18 million. Like, I don't think that would have been a great option for her either. So, you know, those are all things to address.
Yeah. But if she had talked to her attorney at some point, you know, this is a lot of money now. When you wrote it, it wasn't so much money. Now it's a lot of money. Let's reconsider all these things. Let's think about these ages. Maybe we should just have a trustee for the whole till she's 50.
Yeah. You know your kids better than anyone, so you would know whether they can handle that or not. And I think sometimes, you know, in some situations, they're just not, they might be mature, but that doesn't mean they're ready to handle that kind of money.
Right. Yeah. Right. Right.
Okay. So the next one is James Gandolfini from The Sopranos.
Yeah.
He was worth about $70 million when he died, and he died on vacation from a heart attack. And this is one of those big things I hear about when people don't really have an estate plan, is just that they wrote up a quick will before they went on vacation.
Oh, yeah. Yeah.
That's what this was. It was a valid will, but there was no estate tax planning whatsoever. So 55% went to federal and state estate taxes. So, I mean, that's over half of your $70 million. He had a huge art collection. I'm sure quite a bit of HBO money and every other project he'd been on. So that was a big issue.
Yeah. Yeah. That quick, I'm going on vacation will is better than nothing.
Right.
Because at least you have your wishes are carried out instead of dying intestate. And now it's the state's wishes that get carried out. But yeah, he really missed an opportunity to do tax planning. And that's unfortunate.
Yeah. Another one is Michael Jackson. So he created a trust, which is great. Great estate plan, especially for him, that complicated intellectual property.
Yeah, similar to Prince.
He owned more than his own catalog.
Hundreds of times more valuable, but yes, similar to Prince.
Yeah, what we're not going to talk about is estate valuation, because that case dragged on for years with the IRS, because, you know, they want their estate tax, so they'd like that valuation to be
want
high.
A high value.
Yeah, the trustees would like it to be less. So we won't get into all that detail because that's not any of our problem. But what he didn't do was fund that trust. He didn't put anything in it. He wrote the trust and was very elaborate. You know, his mom was guardian to his kids and she was in charge. But because he failed to fund it, it resulted in a probate, which is then public. So, a lot of times we try and assuage people that their will gets lodged, but the will just says everything goes to the trust. And because there's no probate, everything's kept private. But the minute you actually have to file that probate to get everything into the trust, it becomes public record.
So this is one of those examples of what I was saying in the beginning, the things that we say all day, every day. We've said it so many times on this podcast. That's great. You set up a trust, but you have got to actually transfer ownership of the assets to your trust, or you're still going to have a probate, even though you have a trust. That doesn't get you out of probate. And we give our clients at the end of their, the estate plan is done. Here's your spreadsheet. Here are the assets that we already put in your trust for you. Here are the assets. You got to go to your bank. You got to deal with this. But, we give them instructions. It's just fascinating to me that someone like Michael Jackson, nobody gave him a list of go to B of A and take care of this. He had people.
Yeah, he doesn't even have to be the one to do it.
Yeah,
somebody else
should have happened for him. And it's just fascinating that it didn't. That seems like the easiest thing, but oh well.
I mean, he protected his kids for the most part, but it's still this ongoing court battle. And of course, with the probate, everything's under court supervision. So you're very limited as to what you can do without having to constantly go back to court. And there's a couple more in here that are similar to that makes life difficult.
Sure.
The next one is Heath Ledger, our lovely Joker. He died unexpectedly. He had a will, but it was from before his daughter was born. He had a daughter with Michelle Williams. After the fact, he never had updated anything. And as a result, the intestate laws said everything went to his parents and siblings. They didn't even go to his daughter because the will was upheld and they didn't create any predetermined heir. There was no language in there.
Well, okay. And it's kind of similar to Whitney Houston in that the wills were written before the child was born, but Whitney mentioned the child.
Correct. So she was pregnant at the time.
Left. Yeah. But and I'm just going to say that in California, the daughter would have gotten her intestate share because we do have laws that protect against children who are left out of the estate plan just by accident.
Yeah. I'm not sure if his was in New York or Australia. I'm not 100% sure. Yeah. It might have been Australia.
Yeah. So it would have been different if it had happened in California. So that makes me think it was somewhere else. But so we do have laws that protect children that were born after you wrote the will, and also children that were born before you wrote the will, but you didn't know about them.
Yeah.
So in California, at least, we don't like to see those things happen.
Yeah. I mean, it did have a happy ending. Everyone agreed. I'm sure her, aunts, uncles, and grandparents aren't going to be like, you don't get any money, Matilda. So we're going to, they ended up giving everything to her. But it's something that, if you have a child, that's one of those life-altering moments that should make you update your estate plan.
Yeah, that is
even though there's a law in California that provides, you still want to make sure.
Right. Those major life events should cause you to go, oh, maybe I should talk to my lawyer again. Yeah.
Okay. The next one is Florence Joiner, Flo Jo, the track star. She had a will, but no one could find it.
Oh.
So that's the lesson. It took 4 years for them to close out the probate because they all knew she had a will, but no one could produce it. But
so then they had to fight over how should it go.
Right.
Yeah. Okay. So the moral of the story is if you have an estate plan, make sure somebody knows where to find it. And I'm just going to say, I mean, I don't know how they knew she had a will, because how you revoke a will is you just destroy it and you get rid of it. So, an argument could be made that and I'm sure somebody did try to make that argument.
Right.
She just revoked it. That's why we can't find it.
Yeah. It's all that unknown. I think that creates a lot of concern and controversy, I should say.
Yeah, and in her case, it tied up the estate for 4 years, so nobody could move forward.
Yeah, and speaking of unknown and controversy, Howard Hughes died without an estate plan. He had $2.5 billion in today's money.
Yeah.
In today's money, and he wanted it. Everyone who spoke with him, which I'm sure wasn't a lot of people, wanted it to go to medical research, but there was no will, and instead it went to his 22 cousins, which I don't know the man, but I'm fairly certain that was not his intention at all.
No.
It took 34 years to completely settle through the probate system.
Oh my gosh.
There was a lot of undeveloped land, so that,
okay,
we know how that goes. And it's only worth what someone's willing to pay for it. So, and a lot of his land's out in the desert. So he had already gifted his aviation company away before he died. So that was something that he was able to, give who he wanted to give to, which was like an institute of some sort. But this was a fantastical one because there's no, he was so secretive. He was a recluse and had no information. So there were several wives in quotation mark that showed up trying to say that they were married. Yeah. Like in Mexico or in some church of a religion that doesn't really exist or, things like that. And then there were even children, even then of the cousins that were granted a share, the other cousins were questioning their paternity, like, oh, your mom's illegitimate, or which was a relative. Those are each other. They're all related.
They're challenging their own relatives.
Yeah, they had over 600 alleged wives, sons, daughters, first, second, third, fourth, and fifth cousins that filed petitions who all wanted a share. So. Yeah.
Wow.
No wonder it took 34 years. I mean, it is a lot of money. So, I mean, I understand, but that I had no idea. No idea.
Crawling out of the woodwork.
Yeah.
Oh, that's hilarious.
Yeah.
And, unfortunate because we could have used that money for medical research, right?
Yeah.
That would have been great. We might have cured cancer by now.
Yeah. Who knows? Yeah. $2.5 billion. That's a lot. I mean, in today's money, it was almost $1 billion then. I mean, they had trouble valuating it, but even almost $1 billion then is a lot of money.
Yeah. Okay.
Yeah.
Right. Okay. Now we're getting back to a little bit more current.
Yes. So, Anne Heche, the actress, we all know she passed away last month or in August. And she did not have a will. Her ex-husband or ex-boyfriend did say she had a will, but the production that was produced to the probate court, it said it's the body of an email that says, my wishes are that all my assets go to the control of Mr. James Tupper to be used to raise my children and then give to the children. There's been no legitimate holographic will or a witnessed, correctly executed will that's been produced. Mr. Tupper is the ex-boyfriend and father of her 13-year-old son, but she also has a 20-year-old son who has a competing probate petition saying that she died intestate. So
right. And so, again, classic mistake is not having an estate plan, a proper estate plan. And we get this from time to time. It's usually in one of two ways where a client who's doing estate planning with us will say, okay, at the end of their planning meeting, we have it all planned out. And they'll say, well, what happens if something happens to us before we come back and sign the documents? Well, you don't have an estate plan.
Yeah.
Until you actually sign the documents. And a will has to be either, as Madison said, holographic, meaning 100% in your handwriting, signed and dated, or it has to be signed in front of two witnesses. That's it. There's no other way to write a will. The other way we get this question, in my experience, is people will come to us when a loved one has died and say that kind of the same thing. Well, like in the Howard Hughes. Well, they've told me for years that they wanted to leave me their gun collection, or they wanted to leave me their house. They told me that for years. Well, it doesn't matter what they said. has to be in writing.
Yeah.
So
I moved in to take care of them in their last year, and they promised me the house.
Yeah.
And as every attorney knows, those are some of the first few contracts cases when you go to law school, is those deathbed promises in our English common law. So
That's right.
that's always interesting.
Mhm.
The next one is another non-estate plan. Just about as complicated, a little more messy. And that is Steve McNair.
Sorted.
Sorted. Yes, very sorted. And made public because the lack of an estate plan. So Steve McNair was a quarterback for the Tennessee Titans / Houston Oilers, depending on what year. He was killed in a murder-suicide by his mistress. He was married and had two children. He was having an extramarital affair. The mistress found out there might have been another mistress and killed him while he was sleeping, and then killed herself. There was absolutely no estate plan. He had a wife with 2 small children. He had estate plans drawn up, but never signed them. There were just drafted wills. Nothing had been executed. And they were all prior to his marriage. So under Tennessee law, all of that estate plan would have been considered invalid anyways, because under Tennessee law, if you're not married and you have a will and then you get married, it nullifies those previous wills.
Oh, that's interesting.
Yeah.
Okay.
One way to have the pretermitted spouse, I guess, they just knock it all out and you die intestate.
Right.
He had about $20 million in assets. I think that number varies always because you're not sure. Depends on his holdings. But he owned property in 2 states, Tennessee and Mississippi. He had like farming land and things like that. So to make it complicated, it's 2 probates.
2 probates. Yeah.
Everything was frozen. Everything. He has 2 minor children. And obviously, typically a football wife doesn't always, not back then, did they not work outside the house? They didn't have, influencers back then.
Yeah. So she needed that money.
Yeah.
Quick. Yeah.
So she had to ask the court to unfreeze. I think they unfroze about $500,000 for each one and put it in trust for her minor children. I Googled and Googled and Googled, and it is still going, still pending. Some family members are dividing certain things. I assume those are maybe beneficiary designations or in other states, but one of the children's still a minor. So I imagine it's still under some sort of court supervision because of that purpose.
Yeah.
The sordid part is that the apartment building owner filed a creditor claim for unpaid rent on an apartment in McNair's name that housed an unknown 26-year-old woman. So that's the supposed second mistress that no one knew about. But did the family want that to be public in a probate? Those are the things that, I mean, not that people are more concerned about keeping their skeletons in the closet, but that's a for sure way for them to come out. Is to have a public probate.
Yeah. Right.
That's fun.
That is a fascinating story. Lots of little twists and turns.
Yeah.
Okay. So we started by talking about Prince. Now we're going to talk about the Queen.
Yes.
Queen of Soul.
Yeah. So Aretha Franklin, we all know she passed away. She had 4 sons. They initially thought she had died intestate with no estate plan, which would leave everything equally to her 4 sons. They then found 3 handwritten wills throughout the house, one under the couch cushions. They were like on spiral notepaper. I couldn't even read them when I saw the pictures of them. So one of the sons has an undisclosed mental illness. And so I didn't really think much about it. But then the next article said he had a court-appointed guardian, which means he has a conservator in California terms.
So he's pretty severely disabled.
Yeah. So that's a big issue to not have an estate plan and have a special needs child that probably can't manage their funds. Now, I assume if he has a guardian, I don't know if it's of the estate or of the person. So you're handing someone millions of dollars that, maybe shouldn't be getting that. They then found a 4th unsigned will from the year in which she died that would have set up a special needs trust for that son. And I know the estate just paid an $8 million tax bill, including back taxes, and has gone through a few executors. So that's a combination of not having a proper estate plan and not surrounding yourself with the best advisors that you could have. Because,
Yeah.
I mean, back taxes means
Somebody messed up.
yeah, someone wasn't paying taxes for her or telling her she needed to pay taxes or filing
Right.
taxes. But the trial hasn't even happened yet
Oh,
because of
it's
COVID.
still out there. Oh, COVID. Thank you, COVID.
COVID has delayed that trial. It's been over 2 years just since COVID, and she died before that. So,
right. Yeah, I remember when she died. That was maybe right at
maybe
the
like a
beginning of
year
COVID.
or
I don't know. But yeah.
something like that.
Okay.
That school year, that I know, because my daughter was in choir and they,
Oh, there you go.
her choir teacher was pretty upset. So,
okay. Who's next?
So the last one before a little special section is Paul Walker from the Fast and the Furious.
Yes.
Yep, the actor. He was killed in a car accident. He did have a trust and he did name a guardian for his daughter. He did his estate plan when he was 28.
Wow.
He did have his daughter Meadow at that time. So I mean, it was responsible of him to do that.
Very much so.
The trust, the trust wasn't 100% funded. So there's that funding issue again, but
a little bit of a probate. Yeah.
Yeah.
Okay.
The only problem with the only real contest with his estate plan was that he named his mother as the guardian, not the mother of his child. So that resulted in a court argument because the mother did not have custody when he died. I don't know the details. I mean, I feel like that's probably better left private, even if I were to look for the details. But there was an argument between his mom and Meadow's biological mom. And, she was old enough. She was like 14. So she was old enough to, in California,
would
to
have
talk to the judge.
She would be able to weigh in on the decision. Yeah.
Yeah. So she did end up going and living with her mom. But I assume that grandma probably has control over the money. Yeah. Would be my guess.
Yes.
So that was a good example. We had to end the regular celebrity list with a good example.
Kind of a good example.
Yeah. I mean, not everyone's perfect and we don't expect perfection.
No.
But, doing your best is, getting it as done as you can is always a good thing.
Okay.
And the last two are just showing that not even attorneys are infallible from estate planning mistakes. Abraham Lincoln died without a will. Obviously, everything went smoothly because he was the president. A Supreme Court justice got to administer his probate estate, and it was just divided equally between his wife and his and the children. And Congress even donated tax-free money to his wife. We don't know if that was like, I don't know. Here's your severance for dying in office.
Under what authority? The Commerce Clause? I mean, I don't know where that comes from.
So, was it the amount of money would have been the rest of his term had he not died?
In salary? Yeah, we don't know. Well, that's an interesting point. I mean, first of all, he was an attorney. He should have known better than to die intestate. And you cannot rely upon Congress carving out a special dispensation for your survivors. So, think about life insurance. That's not what we do, but we're always counseling people to think about these things. If somebody dies ahead of time, which surely that night in April when he went to the theater, he wasn't thinking he was going to die. You got to be financially prepared too.
Yeah, I'm sure he was like, I made it this far.
Like half the country has been wanting to kill me for 4 years. Yeah.
It's all over. We made it. And then, nope. Yeah. The other one is more recent, so even less of an excuse. I mean, we can give Lincoln the studied law by candlelight a little bit of an excuse, even though all of our probate laws all come from England. So there's really no change in how any of that's worked.
No.
But Supreme Court Justice Warren Burger died in 1995 with $1.8 million in assets. He drafted his own will. And the number one thing they teach you in law school is don't defend yourself. Don't do anything for yourself as an attorney because you can't see clearly if it's yourself. He drafted his own will. It was 176 words. Is that like a tweet? Is that like I tweeted my will?
Yeah, pretty much. Pretty much.
And in that,
no emojis, but
no emojis. He failed to give executors the proper powers they needed to administer the estate. So, for everybody that complains about all the legal jargon in the trusts and wills, just know it is there for a reason,
You
so
need
that you
it.
don't need a probate.
Yeah, you need it.
Yeah.
Oh, that's fascinating. Okay, so I'm just going to throw one in there because I feel as though no discussion of dead celebrities would be complete without a discussion of the king, and then the most controversial dead celebrity, because lots of people aren't maybe still not willing to acknowledge that he's actually dead. People cited him all over the place after his death in 1977. I'm talking about Elvis Presley, of course. Elvis did leave a will. He left everything in trust for his daughter, Lisa Marie, who was 9 when her father died. He left everything to her in trust, but she had a right to take it at the age of 25.
Was the colonel the trustee? Was the colonel the trustee?
No, I don't think the colonel was the trustee. I mean, I hope that's not true. But what happened, he, surprisingly, his estate apparently was only worth about $2 million when he died, which is shocking. His ex-wife, Priscilla, she proceeded to manage that estate, and she grew it to about $100 million by the time Lisa Marie was entitled to take her share away, and she did. And about 8 years, 10 years, 12 years later, Lisa Marie was without any money. She was broke. So there you go. Same thing back to the Bobby, Christina, and Whitney Houston thing. You've got to think these things through. Elvis had every reason to think that he was going to die with a lot of money. And he should have, except he surrounded himself with some shady characters.
Yeah.
So.
And I think one of the big lessons, I mean, in this case, it's mostly for celebrities, but when the child's born with the silver spoon, they probably don't know how to manage the money.
Yeah, they don't.
So, those are those things. I like the idea of if your kids have to get their money, let's make them take a class in financial responsibility first and learn how to do all that. Or we get a lot of clients who are like, I want to make them work with my financial advisor. Mm-hmm. I would like to, or not make them, but I would hope for them. I want to put my wishes and hopes in the distribution. And I think that's a good idea.
Yeah, for sure. No matter how much money it is, but especially if it's millions of dollars.
Yeah.
We all need help. We just do. Okay. So let's look for our audience questions. I will scan back. Here's a question. Does it make a difference where the person lived at the time of their death in how their estate plan is carried out?
If they have a full estate plan, then typically in that estate plan, it has a choice of forum or choice of law clause as to what state's laws are being followed. Mm-hmm. The problem is if they have property in other states that is not titled in that trust or is not covered, then it's subject to the intestate, or it's subject to the probate laws in that state. So typically it still would follow their estate plan. They might have to go through some extra rigmarole to get it there.
Yeah. And also, and in the situation where someone has died intestate, where they live is going to matter. Where they are domiciled is the word. In other words, where they are living permanently without the intention of leaving. That's the law that's going to govern their intestate estate.
Yeah. So, and if they have assets over several different states, it could be several different outcomes. Exactly. And that 99% of the time, that's an issue between a spouse and children. Like that, does the spouse get everything? Do the children get everything? Do they have to split it? In what percentages? That's usually the biggest variation state to state in terms of
how they treat
how that works.
The intestacy. Yeah. So very interesting. Okay. One more question. What kind of estate plan did Queen Elizabeth have?
We had the king, we had the prince, we had the queen of soul, and we had the king.
And now we have the actual queen.
Yeah.
Yeah. So this is what I have come to understand. She was in another country, so they have their own laws. We keep talking about our laws are based on the laws of England, but that place is pretty weird. There's a lot of difference. She had a will. Everybody knows she had a will. That's how they do it there, apparently. But their wills are kept private. Her executor is allowed to request that the will be sealed, and that will be granted, because that's what's historically always happened. She was the sovereign of that country, and as the sovereign, she is not subject to any of the laws. So she's not subject to the civil laws, to the tax laws, to even the criminal laws, and she is not subject to the probate laws. So her will gets probated without doing a probate, and nobody's ever going to know, what her will actually said. It's important to remember that we think she had a lot, but a lot of what she had wasn't really hers. She doesn't own all those castles.
The
She gets
crown
to use
owns
them.
a lot of that.
Yes.
Same with the jewels. That's why they're called the
That's right.
crown jewels,
That's right.
and they're in the Tower of London, and you have
That's
to
right.
request them. And although I'm sure a certain number of tiaras and actual jewelry are hers.
Sure. Yeah.
So we'll know if someone else shows up wearing them. Actually, we wouldn't know if someone else shows
Right,
up wearing them, because they could just request to borrow it from the Tower of London.
That's right. And they do from time to time. We've seen Kate Middleton wearing various items, which are probably owned by the crown.
The only thing we know for certain is that the corgis went to Andrew and Fergie.
That's right. Which is important. That's very important. Yeah. So, and just to point out that no matter how valuable her estate was, she is not paying any estate tax.
Yeah.
The tax laws don't apply to her. So, the one person in the world who can get away with that kind of thing. Anyway, all right. Anything else, Madison? I think we covered quite a few. Yeah,
that was fun. It's always fun when you apply that. And I was telling you before we started that I was watching a show, not a documentary on Hulu last night about the Lakers dynasty and Jerry Buss, and how when he died, his 66% share of the Lakers went to his 6 children equally. They each had an 11% share. And even though he had a trust and everything was laid out, he named 3 of his children as co-trustees, which, if you've heard us before, that is a no.
That is not good. Nope.
And 2 of them went after Jeannie, who's the governor of the board, and the owner of the Lakers by the NBA standards, went after her in court to almost remove her from the board, and she had to take them to court. So the judge said, yes, this trust is correct, and this is his wishes, and you're the trustee. You're not allowed to go against the trust. So even the best estate plan can still be difficult and tricky to navigate, which we see that with our own clients. It's not something that's just held for NBA owners. We see that all the time, where they don't think that mom or dad made the right decision, but it's not, your opinion doesn't really matter in that sense.
Yeah. So we can draft a solid estate plan. What we cannot control is the people.
Yeah.
What people will choose to do with a solid estate plan, no attorney can control that. So that's just something to keep in mind. And if you're going to make 3 children co-trustees, you're likely to get people who are going to do crazy things or disruptive things. So, all right. That was fun. Thank you, Madison, for all the research that you did and for the fun conversation. Thank you all for watching and listening. We are always happy to have you here and to inform and educate. Hopefully this time it was, what do you call that? Edutainment? Educational.
Learning law by pop culture.
Yeah, that's right. Entertaining. And we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.